Hi, everybody. In Chapter 5, we're going to be looking at the justice system. The textbook does have a couple of pages that give you kind of an interesting history of how laws are created across the world. Here in the United States, our legal system was inspired by early English common law, which was basically the idea that they have courts and laws and lawyers. Of course, we had the Constitution that was created here in the United States in 1787. You all don't need a history lesson, but it did establish individual rights. It defined the powers that the federal government has, and it limited punishment for violation of laws. We also have here in the United States state laws and federal legislation, which makes our system one of the most complicated in the entire world. When it comes to different forms of justice, we have retributive justice. It's based on the principle that if somebody is accused of a crime, that guilt must be proven. Once guilt is proven, the offender's punishment should be proportional to the crime committed. Here in the United States, our criminal justice system is based on this type of justice. Utilitarian justice, a principle of justice based on the idea that the greatest good for the greatest number of people. Recently we saw an example of this when with the COVID response here in the United States, where a lot of governors of various states put their states on lockdown for the good of the greatest number of people. Distributive justice concerned with the fair allocation of resources among diverse members of a community. And then we have restorative justice. We look at this a lot in victimology, refers to the informal and non-adjudicative forms of dispute resolution. That means civil law. And it's really about making sure that that victims get some type of resolution for losses that they suffered as a result of being victimized by a crime. And that can include individuals, but it can also be communities as well. So restorative justice takes lots of different forms, but it's really about making sure that people who experience losses because of becoming a victim of a crime get some type of compensation for that. Here in the United States, our legal system is based on criminal law, concerned with the actions that are dangerous or harmful to society as a whole. Our states and our federal government create laws, and laws are really what determine what is harmful to society. So every culture is going to be different in terms of the laws that they create, but it's basically our legal system that defines what is harmful to society, what is against the law. It really defines what constitutes a crime. And it also, every state and the federal government also has the right to decide what punishment will fit any particular crime. That's what makes the United States interesting and so complicated, because you can commit a law and violate a law in one state and get a certain number of years, and then go to the next state and it might be different. Most states are pretty good about being pretty close to each other, but it just shows how complicated our system is, with every state having the right to create their own laws and their own punishments. When you look at the levels of the court system here in the United States, again, very complicated, because we have a district court level or state court level. So every state in the union has the right to create the whatever kind of court system they like, and they all have different names. So it could be superior courts, circuit courts, district courts, general courts. Every state is a little bit different. Every state does have a court of appeals. Every state does have its own Supreme Court, which is the court of last resort. So every state has their rights, but then we also have a completely separate federal court system. It has jurisdiction over cases that violate federal law. The federal court system also has court of appeals. And then, of course, we have the highest court in the land, which is the ultimate court of last resort, which is the United States Supreme Court. This is a schema of how things go through the court system, and you can see how incredibly complicated it is. And again, how every state is going to be a little bit different in terms of the names of the courts that they have. Whether it's a big city or a small city, they might just have one court system that hears all cases. And if you have bigger cities like Atlanta or Nashville, where I live, we have various courts. Now, The first interaction that we have with the criminal justice system after a crime has been committed is reporting the crime interaction to the police. So this is the first step in entering the criminal justice system. The police focus on what happened, who was involved, where it happened, when it happened, and if they don't know all of those things, which they often don't, they will of course be investigating the crime to determine those things, to find the offender, to understand what happened. Often we look at the victim's relationship with the perpetrator. We often look at the backgrounds of the victim, and it's called victimology, looking at the background of the victim, looking at the background of the perpetrator if we know who they are, making inferences about, if we don't know the offender, making inferences about the unknown offender by looking at the crime scene, looking at the forensics. All of that information would be things that we look at in this particular stage with the reporting of the crime and the investigation of the crime. By the way, we have lots of great classes here at the university on criminal investigations, criminal profiling. These would all be really great courses if you're interested in that. Now, the interaction with the police and the victim. I mentioned in the last chapter that this is typically the first interaction that the victim has with the criminal justice system, and that is the police officers. They are most often than not the first people to arrive on the scene. They often observe if the victim is alive, one who is distraught, screaming, bleeding, injured, crying. It is an incredibly emotional time. And it's really important that the police not only be professional and do their jobs, but also have empathy when they see that a victim is suffering, because that can really kind of set the tone for the victim's attitude as they go through the criminal justice system. Police often stay with victims as they go through at least the beginning parts of the criminal justice system, especially through the investigation. But once the case is handed over to the district attorney, the police are not really involved anymore. Then comes pressing charges. A criminal act is against the state, and the victim is a witness for the state. So victims can decide they don't want to testify, but it's not really up to them. It's the state versus John Doe or Jane Doe. And so while the victim is a witness for the state, that doesn't mean that if they drop out as a witness that the state will drop those charges. The state, the district attorney, in most cases, will have to decide if charges will be brought against a person, and even if the witness is not cooperating, they'll have to decide whether or not to move forward with those charges. If a crime has been determined to be committed, a suspect must be identified. Of course, sometimes we know that when a crime's committed. Sometimes it'll take the police a while to do an investigation to try to find that unknown offender. And then again, it is up to the district attorney to decide if charges are going to be brought against a person that has been arrested by the police, or if they don't have enough evidence. It's really just a matter of looking at the evidence that the police gather and determining whether or not they can move forward with pressing charges, and also deciding what charges will be brought against the offender. Part of the decision in whether the victim will participate in the court process, it really kind of depends on the victim, on whether or not it will add to the case, whether it will be detrimental to the victim. And really, the district attorney will discuss those things with the victim if they feel like they need to participate. Some people feel like they want to participate because it gives them kind of a sense of power back. But it's really up to the district attorney, the victim, and really the specific case. Now, before the actual trial, there's a lot of things that goes on behind the scenes before a trial. We have pretrial release. This is whether or not the person that is charged will be detained or released until the trial. This is usually done with a bail hearing. So with a bail hearing, the district attorney and the defense attorney will go before the judge and plead their cases on why or why not this person should be released on bail, and then the judge will determine whether or not that will happen. A preliminary hearing is a hearing to determine if there is probable cause to believe that the accused has committed a crime, and whether or not the case can move forward. So again, this will be between the district attorney and the defense attorney going before a judge. giving the judge the information that they have so far and determining whether or not there is enough evidence to move forward with the case. Now, sometimes that can go with a grand jury. And again, it depends on the state. But a grand jury is, like a jury, a group of citizens who have gathered together. They hear evidence, like you would in a preliminary hearing, against the accused, and then they determine if there's enough evidence to proceed with the trial. Other things that can happen before an actual trial, and by the way, let me say that about 90% of cases never go to trial here in the United States. The vast majority, the charges are either dropped or a plea bargain is entered. So plea bargains are super important in our system. They really do keep our system moving because we have so many cases, and if they all went to trial, we would really have our court system come to a standstill. So a plea bargain is when the defendant pleads guilty to a lesser charge, and the prosecutor may or may not drop some of the more serious charges. For example, if somebody commits first-degree homicide, and again, this will be up to the district attorney, but they might enter a plea bargain with the defendant where they plead guilty, and instead of getting the death penalty, they get life in prison. That's just one example. There's all different types. Other pleas are made sometimes if, for example, with drug charges, maybe somebody is charged with possession or selling of narcotics, and they give information to the district attorney and to the police on who is responsible above them. And by giving that information, allowing the police to go after the higher ups in the drug trade, that person gets a lesser charge. We also have suppression hearings where the defense will challenge the prosecution's evidence, try to get evidence thrown out. There are a lot of hearings that go on before a trial ever takes place. A change of plea hearing, this is when the plea from the charges from not guilty to a plea of guilty as part of an agreed sentence. This happens when somebody enters into a plea bargain. They are required to go in front of the judge and in front of the judge say that they are changing their plea to guilty. The district attorney will outline what the sentence will be. The judge will ask them if they understand the plea bargain and if they willfully enter into the plea bargain. We want to make sure that everybody understands when they're entering into a plea bargain, especially since it happens so often in our system. Now, again, the vast majority of cases never go to trial, but if a case does go to trial, our court system is based on an adversarial system of law, meaning we have a prosecution and a defense. The defendant has the right to see his or her accuser and to hear all the evidence against him, so the defendant will always be in the courtroom. They have the right to a jury trial. A jury trial is when we have members of the community who are brought in to sit in judgment. They can also, by the way, choose what's called a bench trial, and that's where it's just the judge that will hear all the evidence and decide the case. The victim's right to hear testimony. Victims do have the right to be present at the trial. Now, there can be, problems if the victim is going to be a witness. They might not be allowed in the courtroom during certain testimony because they don't want to have their testimony influenced by anybody else. So it really kind of depends on whether or not they are going to be a witness. Civil commitment for sex offenders. This is an interesting concept, and most states actually have this. So this is when we have civil commitment of habitual sex offenders to keep them away from society. And this is even after they have served their sentence. So if they, let's say they got 10 years, and after 10 years, the court deems them to still be a threat to society, they can use civil commitment laws to keep them committed for an indeterminate amount of time. So they can be held as long as warranted to successfully treat them to satisfy public safety concerns. This is very controversial because this does apply when people have actually already completed their sentence, their punishment. But the Supreme Court ruled in Kansas versus Hendricks in 1997 that such laws do not violate the Constitution's double jeopardy or ex pacto clauses. So this does move forward in some states, and it is controversial. All Right. At the end of the trial, if a person is found guilty by the jury or if they have a bench trial by the judge, the trial moves into what's called the sentencing phase. And during the sentencing phase, there could be a hearing, or maybe the judge just enters a sentence. It kind of depends on the laws of every state, but at a sentence hearing may be held at which evidence of aggravating or mitigating circumstances are considered. Aggravating circumstances would be those typically brought forth by the prosecution on why this person is dangerous and should get the maximum penalty. Mitigating circumstances are usually brought up by the defense and would be factors that should mitigate the seriousness of the sentence. So you might have, for example, let's say somebody is given the death penalty for, or is having a sentencing hearing that they could get the death penalty or life in prison for first-degree murder. You might have the defense attorney bring up the person had a childhood that included, serious abuse and neglect as a mitigating circumstance on why they should not be given the death penalty and instead should be given life in prison. A restitution order can be included in the sentencing order, and that would be restitution to the victims. This is the time when, remember we talked about victim impact statements. This is the time that would be read, either, by the victim, sometimes the attorney, sometimes it might be somebody that is appointed by the district attorney's office, sometimes it could be a family member. There are all different ways that this could be brought into court, but we talked about how victims do now have a right to have their impact statement read at the sentencing so that can be taken into consideration when determining the sentencing for the offender. Now, if an offender is found guilty of a crime, they could be, depending on the charges and the type of crime, sentenced to incarceration. If it is a felony that has a year or less in terms of the sentencing, they might serve out that year in a local jail. If it's a felony that the sentence is over a year, they're typically going to a prison. So the difference between the two is the length of stay for inmates. People are held in jails while they are awaiting trial. Or again, if it is a less serious offense where, let's say, the incarceration is going to be 6 months, they'll go to a jail. So anything under a year will be a local jail. Anything over a year will be a prison. Parole is when an offender may become eligible after serving a specific part of their sentence. And if they are eligible for parole, they will go before a parole hearing who will hear evidence. Victim statements can be read at parole hearings, and the parole board will determine whether or not that person should be let out on parole. So you might find somebody gets, let's say, 10 to 15 years for a particular crime, and they'd be eligible for parole after 11 years. So after 11 years, they will go before a parole board, and they will hear from the offender. They might hear from the victim's family or hear a victim impact statement, and then the parole board will decide whether or not that person should be let out on parole. When a person is given parole, they are now under community corrections, so they are not set free, so to speak. They have specific guidelines that they have to follow. They have to check in with the parole officer, so they're still followed in part of community corrections. And a lot of times offenders are required to serve out their full sentence before release. So somebody might be given 10 to 15 years and they're just required to serve a full 15 years. And that's just the way it is. Again, every state is different in terms of how in terms of their sentencing laws. We talked a little bit about restitution previously, and restitution is really about returning, repairing stolen or damaged property, making sure that victims get restitution for their personal injuries, for suffering, for missing work, missing school, all of those things. And it can be a direct order of restitution or restitution fines. Sentencing court can order the defendant to pay restitution to the victims. In most cases, when somebody is sentenced to prison, there's really not a lot of funds available unless the person has some personal property that could be sold in to give the victim restitution. But if somebody's sentenced to life in prison, there probably isn't much chance of getting much in the term of restitution. I talked about parole hearings. The purpose is to determine whether or not an inmate should be released from prison to community corrections. Certain criteria certainly must be met, and again, parole boards will listen to lots of different testimony to determine whether or not this person is still a threat to society and whether or not they've met the criteria. And even if they are put on parole, they do have to follow very specific rules and regulations under parole when they are out in the community. When it comes to the parole hearings, generally limited to the victim and the victim's next of kin or immediate family members, the offender will be there as well. Victims of crime who wish to be notified of parole hearings need to register for that, and then they will be notified every time a offender comes up for parole, and then they can determine whether or not they would like to make an appearance. They can make a video statement, they could submit a written or recorded statement, or they can request to be present and give an oral statement. So it's really up to the victim on what type of appearance, if they want to appear at all, and what type of appearance they want to make. And the results of the hearing will be given to the victim upon request. All right, capital punishment and the death penalty. The death penalty has roots in early justice systems. The U.S. Bill of Rights in 1791 controlled the use of capital punishment, not abolished in any state until the 1950s. But really, the use of capital punishment was found unconstitutional here in the United States in the 1970s. However, the Supreme Court found that the way that the death penalty was applied was arbitrary. So what most states did is they changed the way that it was applied. And in the late 70s, early 80s, the death penalty was reinstated in many states here in the United States. Most southern states have the death penalty and some other states as well. The death penalty can, because of the changes that were made in the 1970s with the Furman case, the death penalty can only apply to first-degree murder cases now. So it used to be before that it could be given to people who were convicted of rape. But today it is first-degree murder, and only in those states that have the death penalty. And by the way, the federal government also has the death penalty. So it will really just kind of depend on the state. Critical issues in the criminal justice system that we have to think about: the period from arrest to pretrial detention. People are sometimes held for a very long period of time, especially if they are not given probation. Given a bond. So that's definitely something that we have to think about. And do we want to keep people, in jail, or for 3 or 4 years while they're waiting for trial? But it happens all the time because here in the United States, the court system is very slow. We have all of those pretrial hearings that take place. So it's a really long time from the time a person is arrested, if they're going to go to trial, from arrest to the time that the trial starts. And then some trials are months long. So they would be detained if they're not out on bond during the trial stage as well. Another critical issue in the criminal justice system is reintegration of incarcerated offenders into society. The vast majority of people who are in prison today are going to get out. And if we don't have rehabilitative programs in place, the vast majority of them are going to reoffend because they have trouble reintegrating into society and finding legitimate means to make a living. Not a lot of people want to hire convicted felons. So it's a really tricky and difficult situation. And it's part of the reason that we have such high recidivism rates here in our culture, because in the 1970s, we really moved from a rehabilitative correctional system to a punitive correctional system. So we don't have a lot of programs in place that really aid offenders into successful reintegration into society. We're more punitive now. Probation is another issue in the criminal justice system. A lot of people don't like the fact that some offenders get probation instead of going to prison. Probation is typically used, and probation, by the way, is a form of community corrections. Again, if you're given probation, you have a very strict set of rules that you have to follow. You have to check in with your probation officer. And it will depend on the crime, the number of times a week you need to check in with your probation officer, and they will set the rules. The court will set the rules that you need to follow in order to maintain your probation. If you violate your probation at any time, the court can go ahead and impart a prison or jail sentence. But a lot of people don't like the fact that some people do get probation instead of jail or prison time. But the vast majority of people that are given probation are for low-level non-violent offenders or first-time offenders. So, for example, somebody that is arrested on a drug charge and it's their first offense, they might be given 2 years of probation as opposed to a prison sentence. But it's controversial because, we can understand why victims would not be happy with the fact that somebody gets probation instead of a jail sentence, because it doesn't seem like as harsh of a punishment, because the person still gets to, be out in the public. Civil justice system is, and by the way, we have a criminal court system and a civil court system. So civil court system is a system of private justice that governs transactions and grievances among individual citizens. It does not involve criminal charges or jail time or prison time. It is usually two parties or corporations filing charges against one another, one against the other. And the punishment is typically financial restitution. So with civil cases, we typically have some type of financial award that will be given if the claim is found for the person that has brought the charges. Civil courts attempt to discern whether an offender or a third party is civilly liable for the injuries sustained as a result of a crime. Civil justice system can provide victims with more of the monetary resources that they need to help rebuild their lives. If you think about the O.J. Simpson case, and most of you are probably familiar with that, you'll remember that, or maybe you've seen the movies or the documentaries. O.J. Simpson was charged in criminal court with 2 counts of murder. He was found not guilty of those charges. So the families of both of the victims brought civil charges against O.J. Simpson. So the case was heard in a civil court, and in the civil court, he was held liable, and a monetary fine was enacted against O.J. Simpson, and the proceeds to go to the victims' families. Here's the process for a civil claim. You can see it's, again, not as quite as complicated as our criminal court system, because it's between 2 parties. A plaintiff is the one who files the claim, and the defendant is the person that the charges are filed against. And again, remember, this is not criminal, this is civil, so it's going to be financial and not going to prison or jail. Considerations for pursuing civil action. The control is in the hands of the victim, so it does make the victim, especially if the case, like in OJ's case, if the criminal courts found the person not guilty, payment can be awarded for restitution. Recovery award is not always straightforward. O.J. Simpson is a great example of that. The justice system does not have the right to get all of the person's finances, like you saw with O.J. Simpson. They couldn't get his retirement. Recovery award is not always so it's not always straightforward, and there's no guarantee that you're going to get the money. Victim's history and medical treatment are open to scrutiny, so the victim has to kind of be prepared for that. And remember, there's not going to be a district attorney involved in this. This is going to be private attorneys. Statute of limitation is the time limits for filing any suit, and it's generally 1 to 3 years after the offense or the grievance took place. Longer limits with respect to obtaining compensation, up to 20 years. That's for obtaining the award. Now, in addition to the adult criminal court system, the civil court system, we also have the juvenile justice system, where the goal of the adult criminal court system is punitive. Theoretically, the goal of the juvenile justice system is to rehabilitate. Courts usually have jurisdictions over matters concerning children that include delinquency, neglect, adoption, Delinquency would be any crime committed by a child under the age of 18, or any status offense under the age of 18. Status offenses only apply to juveniles, like truancy or drinking under the age of 21, smoking under the age of 21, running away. Those would all be status offenses, and they're only crimes if you're under the age of 18. When a young person is arrested, a decision is made to either keep the matter in the juvenile justice system or to waive the case to the adult court system. All states do allow juveniles to be tried as adults in criminal court under certain circumstances. Typically, and the age will vary by state. Remember, all states have the right to make their own rules. So typically it's 14 to 16. But for example, in most states, if let's say a 14-year-old commits first-degree murder, in almost all states, they will be waived to the adult criminal court system, and their case will be heard in the adult court system. Most violent crimes, so homicide, aggravated assault, and rape would be examples of crimes that the district attorney, the judge, has to decide whether or not to keep the case in the juvenile court system or to waive those cases to the adult criminal court system. By the way, that's a very important decision to make, because once a case is moved to the adult criminal court system, there's no going back to the juvenile system. Once a juvenile is under the juvenile court disposition, the court may retain jurisdiction until the juvenile legally becomes an adult. That's depending on the state, anywhere between 18 to 21 in most states. Following release from an institution, juveniles are often ordered to a period of aftercare, similar to parole supervision for adult offenders. And by the way, there is probation specifically for juveniles as well. So instead of being sent to a juvenile facility, a lot of juveniles are put on probation. Has the same kind of rules that you would find for adult probation, and there are people who specifically work as probation officers for juveniles. All right, so that is the criminal court system here in the United States. Very complicated system that we have here. Can be a little bit confusing because we have states and the federal government. If you have any questions about anything in this chapter, let me know. Otherwise, have a great day.